VNC into my computer, type a phrase that I don't know. And every time I need to access that file, I have to hope they're online and hope they VNC in. Does it really just come down to how crotchety the judge is or something? And if they say, you have to decrypt this, and I say, I don't know. I don't know who this person is. Am I still looking at a contempt charge? Or am I looking at like, well, you obviously were doing something wrong anyway?
It depends on the system of law. In Canada, you would be held at the Queen's pleasure. She's usually happy, but sometimes I've heard she can be tough. She was a mechanic in the war, you know. You're probably going to be in jail until you figure out how to find that person. We've had more questions about key obfuscation than any other part of this talk. And what it comes down to at the end of the day is they'll get your key. There's this place where they send people they don't like. It's a holiday island destination, really. I don't think they'd actually send you there, but when you look at it, and actually you're the perfect person to talk to about this. It's deviant Arlen, by the way. When you look at it, is your encryption key really any different from the key to the front door of your house? Or
yes and no.
Under law, is it almost exactly the same thing?
Interesting way of thinking of it.
So maybe the cops just don't want to bust your door down. Maybe they're going to ask you for your keys. And generally speaking, if they arrested you, they'd have the contents of your pockets. They'd probably not bust your door down. Some of them would, because they like doing that. But probably they'd just take the keys out of your evidence packet and go and open your door.
And for instance, the first World Trade Center bombing of when they bombed the garage in one of the World Trade Center buildings, there was a laptop recovered, and it had really, really good encryption on it. The perpetrator accused of the crime never turned over the keys, and still the NSA to this day has not been able to break it.
But he's also still in jail.
All righty. Thank you very much.
I have a question on the FAST thing. Do you have any information on how they're balancing the false positives and missed negatives, the alpha and the beta risks? How they calibrated that?
Right now, there are really high false positives, but they claim by next year, before they roll this out, it will be less than 0.1%. That's pretty incredible when they're talking about thought crime reading.
But they're going to build it using the biometric standard, which is it's better to be extra right than it is to be wrong. So it's going to be built in the wrong direction. This is the problem with...
Does that mean they're going to maximize not missing a terrorist, or are they going to maximize or minimize the risk of arresting an innocent person?
They don't care how many people they have to process through the little dark room.
Okay.
They're going to pull everybody in that they possibly can.
Okay.
Yes. From purely a legal standpoint, in your talk you used contempt charge several times, and generally the public opinion is they're going to get you anyway. Is the contempt charge becoming kind of blanket bust your door law that can be used in pretty much any situation without any process or anything, or there are limits to where it pretty much ends and there is nothing anybody can do to you?
So, quick rephrase on the question, is there a limit to what you can be held for in a contempt charge? It's jurisdictionally challenging. Some jurisdictions, if you sneeze in court, you can be held on a contempt charge. There was a case actually just last week of a guy who yawned loudly in court and was held on contempt charges.
In the United States, contempt is a really interesting kind of area where there's an episode in a 1990 show, Ally McBeal, where a lawyer was held in contempt for having a skirt too short. There was a Emmanuel Goldstein was in a case, and a judge found that a lawyer was wearing, I believe, pants, and women should wear skirts in court. I mean, leather. Okay, yeah, and she went and bought some leather stuff, and then he said, "You're mocking my court." So judges are very strict when it comes to what's in their courtroom, and they can hold you in contempt for a very long time.
But is it absolute or is it appealable?
It depends on if you have a court order and you're told to do something such as turn over your crypto keys and you don't. I think that's one that's you're gonna sit for a while. If it's about clothing or not saying Your Honor, I've heard people not say Your Honor, even lawyers, and they're held in contempt and spend a night in jail. That's something that could be appealable. But I'll say if it's technical, like a lot of the cybercrimes cases I do, if you're in contempt for not turning over keys, that's concerning. It's not as easily appealable.
Yesterday there was a talk about detection in malware software, and they used a technique called TLP, which is time lock puzzles, which will allow you to encrypt data in such a way that it won't be, unless you have the key, it won't be decryptable in a set amount of time, say 10 years. And say, for instance, you take a completely random key. You don't know the key. What happens legally to you when you present, well, I have this data, you can have it, but you won't be able physically to open it in 10 years. And I can't give you the key because it's completely random.
We talked about this. James and I were talking about this. If you tell a court that, you better be really convincing that you don't know the key. You can't get it for 10 years, even with the court or the law enforcement trying a lot of things. They're going to really put you through the ringer for that one. I mean, from the cases I've seen with cybercrimes, and really, if you want to protect your data, encrypt. I mean, everyone knows that, I think, in this room. But it is going to be, I think there's going to be some interesting vehicle cases coming up about breaking encryption, and for what lengths they will go through to get that. They're going to want to get that. Or you might spend some time, I wouldn't say 10 years in jail unless you're a World Trade Center bomber, but you might spend some time in court while they're trying to work out how to get your key, and technically if you're telling them the truth and you're convincing.
And again, this depends probably on what you did. We had a conversation earlier about the idea of exigent circumstances. Like there's an important reason we need this data now, not just that it's convenient for the court that we need it now, but that we actually need it now, for example, to protect a minor, or another great reason. Sort of the better the reason they have to get that data, the more likely they are to hold you to it. So like Tiffany said, the World Trade Center, the first bombing run, in this case, let's make you a really bad guy. And honestly, I don't know you, and I apologize for this, but we're talking hypotheticals. So hypothetically, you're a really bad guy. There's a minor in danger. Information relating to the location of that minor is in your 10-year crypto puzzle. They're going to hold you for 10 years, and they're going to work really hard to get that information out of you. There's a line between how hard they can work and how hard they can work. They're going to work the second kind of hard. You will hurt.
Okay, thank you.
Thank you.
Yes, one part that I thought was particularly scary was when you were talking about pacemakers and other medical devices and how you could potentially subpoena data from them. That's horrible.
Yes.
But it's so obviously horrible. I'm wondering what you think about the possibility of using that sort of case to present to policymakers and say, look, this is not good, and then use that to maybe gradually get them to realize what's going on in the big picture.
The use of log data in determining time of death is established. It's a talk that's commonly given at medical forensics conferences. The best ways to remove an implantable device to ensure the forensic quality of the data. So it's not to ensure the medical forensics, but to ensure the forensic quality of the data. And because this is a commonly given talk, and because this is used to set time of death, it's going to become one of those, they always seem to happen in healthcare, those terrible balances between the best things for the greater good and the best things for personal privacy, and it's going to become regime dependent. For example, Canada has very strong information privacy law. Our health privacy law is a mess because it's provincially based, so there's 7 different privacy laws for health information, which is the invert of the United States, where health information is a federal law and it's well done, and information privacy is shattered amongst the states. In the EU, it's a little of both, so it depends on jurisdiction how much your privacy counts.
And I'll say quickly, while we're talking